Welcome everyone to this event today, which, as Annie has mentioned, the International Bar Association is co-hosting with the Scotia Group. I want to say this Scotia Group is really doing some remarkable work in this climate advocacy field, and we're delighted to partner with them. Malik, who's on the screen now, I think is leading this effort, and I can't say enough about what he's doing. It's really quite remarkable. Some of you might know, others don't know, that the IBA has more than 80,000 individual lawyers from most of the world's leading law firms, and we also have over 190 bar associations from, I think, around 170 countries. So it's a fairly inclusive association of lawyers, and it is a global membership. And when I say global membership, it means that it spans every conceivable area of law that one can imagine. And we've tried to focus really on the development of international law and on the future of the legal profession as well. But in doing so, we don't do it just by ourselves. We join and we partner, an example with Scotia Group, but we also with a number of other international organizations, the UN, the IMF, OECD, the World Bank, the European Union, to name just a few. And in fact, all of those institutions are also focusing on this very important area of climate change. We've been committed over the last decade to address kind of the fundamental rule of law questions that relate to the climate change. And when I think back to when we started, it was actually in 2012 at the IBA annual conference, and Mary Robinson spoke at that time, and she stressed the urgency and the magnitude of the climate change crisis, and really challenged the IBA to develop a working group on climate justice to provide leadership in shaping the global response, we think, to climate change. And that's exactly what we've done. So we moved towards establishing a task force on climate justice. That task force published its first report entitled Achieving Justice and Human Rights in the Era of Climate Disruption. It then went on to launch the Model Statute for Proceedings, challenging government failure to act on climate change. This came out last year, and this really will be the focus on today's discussion. So, but for the IBA, both reports highlight the role of public sector litigation, and it's litigation in assessing whether governments are taking sufficient action to protect the public on climate issues. And we think that's exceedingly important. And for the IBA, we are increasing our focus both to the business community and to the general legal community at large about the advocacy and the need to focus on climate justice. So we're very proud to be part of that initiative, and particularly today. I want to now ask, if I could, Sarah Carnegie, who's the director of the legal projects for the IBA and is formerly a criminal barrister and senior government lawyer for over 20 years. Sarah is one of our top staff lawyers at the IBA. She's really quite extraordinary. I want to thank her for her leadership in making this event happen. And I want to thank this distinguished panel that we have that you're going to hear from today that represents really the best of the IBA. So Sarah will moderate this session and she'll introduce our speakers. So I'll hand it over to you, Sarah. Thank you all again for being here with us.
Thank you very much for that very generous introduction, Mark. And it's a pleasure and honor to be here today, and a heartfelt thanks also to the Scotia Group for inviting us to host this dialogue. The context for our session today is as described by Mark, but it's also important because of the dramatic increase in climate litigation cases where the impact or the worsening of the climate crisis are the core issues. And figures published that you may have seen, published in early July by the Grantham Research Institute on Climate Change and the Environment at the London School of Economics, show that there's been an unprecedented number of key judgments with potentially far-reaching impacts in the last 12 months alone. We've seen that cases have doubled since 2015, according to the research, and as it stands, there have been over 1,800 cases identified across different jurisdictions around the world since 1986, with over 1,000 of those cases being filed since 2015. And 2015 was a pivotal moment for climate litigation. We know that the Paris Agreement created a binding treaty, albeit with non-binding targets, for 196 countries who agreed to draw up their own ambitious, nationally determined plans to achieve this. And campaigners such as those involved in the TheUrgenda case and Shell case have successfully used the agreement as a legal peg on which to hang climate justice claims. I think one particularly striking aspect of climate litigation is that we're seeing new types of plaintiffs who are bringing cases to court. The recent Sharma case in Australia saw a group of young people emboldened to bring action, and the landmark case in Germany recently took activists took the German government to court for setting emissions targets too far into the future. So these cases involve new arguments that have been persuasive and are occurring in more jurisdictions as lawyers share tactics and know-how across borders. Almost every legal system we've seen contains legal tools that can be used to hold governments to account for their insufficient action to combat the crisis. So as Mark mentioned, the IBA has identified legal hurdles and issues in its 2014 report, and then the Model Statute report, which was published in 2020, which was trying to describe how one overcomes such hurdles, such as concerning access to courts, evidence and disclosure. And you're going to hear about that from David Estrin shortly. So there is a significant and growing legal toolbox available to lawyers, and this is where the IBA has continually sought to flag what can and what should be done, in addition to providing further guidance through a wide variety of reports and its recent climate crisis statement that we published in 2020, which was also encouraging further action and legal education in this area. Legal tools include bringing cases against governments and against companies, taking action to stop companies or others engaging in environmentally damaging activity, giving advice to clients to improve or change their approach, incorporating new contract clauses to address environment-related issues, and devising ways to finance clean energy projects and transactions. We're seeing a change in how law firms approach these issues with a greater emphasis on ESG, which was a term barely used a couple of years ago and which is now in almost every legal and business communication that I see. The younger generation is also driving some of this change that we've seen in our broader work, driving firms to prioritize it and stimulate them to pay more attention and make different choices. So I'm delighted to now be able to introduce our speakers today. We have three hugely experienced practitioners, one of whom will be joining us partway through. He's been unavoidably delayed, I'm afraid, this morning in US time for him by a member of the Biden administration who's called him in for a meeting and couldn't be refused. So he will hopefully join us partway through. But certainly I'll be starting with Suzanne Spears, who is a partner in the International Arbitration Group and co-head of the Global Business and Human Rights Practice at Allen & Overy here in London. She's recognized globally for her expertise in business and human rights law and has represented clients in international disputes under all the major arbitration rules and before the International Court of Justice. She has particular expertise in involving human rights in disputes involving Latin America and Africa and the energy and natural resource industries. Next, you'll hear from David Estrin. David's impressive 4-decade environmental law career has combined litigation, teaching, research, and writing, as well as being an expert witness in international environmental arbitration and human rights tribunal proceedings. He's the founding editor of the Canadian Environmental Law Reports, and for many years headed the Environment Law Group at one of Canada's largest law firms. He chaired the Environment, Health and Safety Law Committee at the IBA and co-chaired the Presidential Task Force, which produced the 2014 report we've referred to, and also co-authored the 2020 IBA Model Statute report. Finally, Roger Martella, who is the Chief Sustainability Officer at General Electric, where he's responsible for leading the comprehensive approach to sustainability for the company. Before joining General Electric in 2017, he was Director and General Counsel for Environmental Health and Safety at Sidley Austin. He also served as General Counsel of the US Environmental Protection Agency, as well as the Principal Counsel for the Complex Litigation for the US Department of Justice's Natural Resources Section. And along with David, he was a co-chair on the Model Statute work and vice chair on the Presidential Task Force. So a tremendous array of expertise from our speakers. So I now turn to Suzanne for her presentation on these issues. Thank you very much.
Thanks very much, Sarah. Now, I do have some slides, but I'm showing that function's been disabled. Oh no, maybe I can share slides. Just let me try to do that. If you'll bear with me for just a moment. Are you able to see slides for me? Sorry to have to ask, but can somebody nod?
Yes, we can see
Yes,
them.
Yes.
Thank you very much. I appreciate it. Right, and I will just, terrific. Well, thank you so much for having me, and thank you for that introduction, Sarah. And it's wonderful to be with all of you, and including with the Scotia Group, which I recognize is a group of preeminent global citizens focused on addressing climate change. And very much as a lawyer, I appreciate that the initiative is going to underscore the importance of the rule of law as a driver for climate action. And likewise, of course, the very important role that the IBA has played in this. And I call myself a proud member of the International Bar Association. So thank you very much again for having me. My role today really is to set the scene and then to talk a little bit about some of the climate change cases that have occurred by way of some introduction for then David and Roger. I want to talk briefly over where we are in terms of the overwhelming scientific evidence showing that really there's only a decade left to collectively facilitate an energy transition. You can see from the commitments made in 2015 that the goal needs to be, according to governments in Paris, that we need to limit climate change to well below 2 degrees Celsius and ideally to 1.52 degrees Celsius by comparison to pre-industrial levels. Now, clearly we all know that achieving these aims will require a very steep decline in global greenhouse emissions towards net zero by 2050. And that in turn will require a very rapid movement away from carbon intensive products and development and the diffusion of carbon emission, zero emission technologies. So in short, reducing emissions at the scale committed to in Paris requires both economic and social transformation at a dramatic scale based on the now clear science. Now, the good news is that 137 countries have committed to carbon neutrality. Some have done so for earlier dates than others. 90% of the commitments are centered around 2050. There are some early achievers. We found Bhutan and Suriname are the only two countries that have achieved carbon neutrality already. And Uruguay has targeted 2030. And a number of countries are aiming to speed up their targets to be ahead of 2050, including countries in Europe such as Finland, Austria, Iceland, Germany, and Sweden. They're all targeting 2045. Now, we only have a number of countries who are pledging later than 2050, including Australia and Singapore, which haven't set firm targets. Now, what we do find, which is good news, is that 73% of global emissions are currently covered by net zero targets. But really setting a goal is the easiest step towards carbon neutrality. The real challenge is in solidifying that goal and starting to make progress towards it. So that's why it's important to consider how deeply committed each country's carbon neutral pledge truly is. Now, the most rigid commitments are enshrined in law, which is why we are talking about law and litigation today. We also see, of course, government policies, but those can change alongside changes in government. Now, what we want to see is some of these pledges transformed into legislation. Now, we have seen that in countries such as Sweden, Denmark, France, Hungary, New Zealand, and the UK, as well as across the European Union, transforming carbon neutral pledges into law. And there are other countries that have such legislation in the works. A number of other countries, as I said, have carbon policies. Now, more than 72% of these pledges are still under discussion in terms of not having a formal status yet as legally binding commitments. Now, in its 2018 report, of which I will show you an image in a moment, the UN Intergovernmental Panel on Climate Change warned that to achieve the Paris Agreement's most ambitious goal of keeping global warming below 1.5 degrees Celsius, we need to reduce global greenhouse emissions by 50% by 2030. And the map on the right-hand side, at least to me, of my screen, shows that almost 75% of the climate pledges to date are partially or totally insufficient to contribute to meeting that goal. And the emissions from the top 4 emitters, being the US, China, India, and the EU, which combined contribute 56% of global GHG emissions, these emitters are not yet doing enough to meet those targets. So this was the state of play in 2018, according to the ICC panel, and undoubtedly showing that we would miss the 1.5 degrees Celsius target the way we were going in 2018. And clearly this is why the UN climate talks later this year in Glasgow are so very important. As US climate envoy John Kerry has put it, COP26 provides the last best hope we have to get the world on track to avoid runaway climate change and a climate catastrophe. So at COP26, governments will really have to step up and define in very real terms what their roadmap for the next decade and then the next 30 years is going to be. Now, the urgency for this was underlined, as Sarah has already emphasized, a few weeks ago with the publication of the IPCC's latest study, which confirmed, if there were any doubters, that human activity is changing the climate and warns of the impact that this climate change will have. Now, the UN Secretary General has called the IPCC report Code Red for Humanity, and really it flags that climate change action is urgent in the coming decade. Now, as Sarah's already alluded to, we have an enormous amount of climate change litigation, a large percentage of it filed since the Paris Agreement in 2015. And this really shows citizens, NGOs, and others bringing their grievances against governments as well as corporates to bear to try to prompt further action and to address the climate crisis. Globally, the cumulative number of climate change related cases has more than doubled, as Sarah already said, since 2015. And outside the US, which is, as one would expect, the leading jurisdiction, we also find a large number of cases in Australia, the EU, and the UK. And these strategic litigation type cases really are on the rise. There have been a number of very significant decisions even in the last 12 months, including a case against Germany, as well as, you'll know, the famous well-known case in the Netherlands against Shell in particular. And these cases may have very significant impacts on the future of climate change litigation. We do expect an ongoing rise in this kind of litigation in the coming years, and a number of NGOs have said they will take the new IPCC report to court with them when they go. The types of claims and actions that we're seeing, Sarah's already alluded to, we are seeing a large number of claims against governments. These tend to form 2 broad categories. We have human rights and constitutional claims, which are, of course, claims that governments must set more ambitious targets and adopt more stringent laws. Then we also have administrative or judicial review type challenges that say that governments should not permit or support projects that are going to emit further emissions and contribute to cumulative climate change. I don't have time to talk about very many of these cases, and I'm keen to make sure that I conclude in just a minute. But I'll talk about the most famous of the cases. You will have heard of the TheUrgenda case against the Netherlands. This was the first case in the world, and it was back initially, the first ruling was in 2015, but it was affirmed in 2018, in which a court ordered a state to achieve a greater reduction in greenhouse gas emissions in the absence of any statutory obligation to do so. And the ruling was simply based on general legal principles and human rights provisions. This case was really quite revolutionary because when the court upheld it, the Court of Appeal of The Hague upheld it, it relied on Article 2 and Article 8 of the European Convention on Human Rights as the basis of the member states of that convention's obligation to take more action to fight climate change. Now, this case really represents a so-called greening of human rights law. In other words, rather than creating new causes of action against governments, this leveraged existing substantive rights, for example, to a clean environment and to human rights, rather than reestablishing some new or establishing some new climate change rule. Now, there have been a number of other successful cases, and I don't have time to go through those, but as Sarah alluded to, there's been a successful one against Germany, Belgium, Switzerland, Pakistan, Colombia, and the list goes on, and there are a number of cases pending around the world against governments. I just want to briefly touch upon some of the unsuccessful cases, because I know that will set up well for Roger and David to discuss why there was a need for a new statute. One of the key examples is the Juliana case in the United States, which was filed by a group of young plaintiffs alleging that despite knowing of the hazards from increased carbon dioxide from burning fossil fuels for more than 50 years, the US government and its agencies have continued policies and practices allowing the exploitation of fossil fuels. And the plaintiffs supported their allegations with compelling evidence, according to the Ninth Circuit, which heard the case. Nonetheless, the Ninth Circuit had to reluctantly conclude in a 2-to-1 decision that the plaintiff's impressive case for redress must be presented to the political branches of government. And the court found that, unfortunately, the plaintiffs lacked what we call in the United States Article 3 standing to pursue their claims. In effect, they found that their claims were not redressable by the judicial branch, and only the legislative branch could redress these claims. I commend to you the dissent in this case. There was quite an effective and dramatic dissent in which the dissenting judge found in these proceedings, the government accepts as fact that the United States has reached a tipping point, crying out for a concerted response, yet it presses on towards calamity. And she says, it is as if an asteroid was barreling down on the Earth and the government decided to shut down our only defenses. Seeking to quash this suit, the government bluntly insists that it has the absolute and unreviewable power to destroy the nation. It was quite an effective, or at least it wasn't effective in the sense that the case did not prevail, but it was at least a dramatic and well-read dissent. I'll finally conclude on another case that was declared inadmissible recently. In a judgment dated 25th March 2021, the Court of Justice of the European Union was asked to look into an appeal against an order of the General Court in which a number of individuals had sought to force the EU to adopt more stringent greenhouse gas emissions targets, and also to annul the EU's legislative package on greenhouse gas emission reductions on the basis that it didn't go far enough. Again, here, while the subject matter to the case was focused on fundamental rights in the context of climate change, and the court did not dispute the compelling nature of those rights, as well as the evidence presented, the court found that, in fact, these were not claims that were redressable by the court because the plaintiffs themselves were not directly and individually concerned by the EU legislative package on greenhouse gas emissions. Therefore, those plaintiffs had no locus standi to initiate such an annulment request. So the fact that fundamental rights were at issue did not overcome this fundamental procedural hurdle that these claimants were faced with. Now, we have some hopeful cases still in the pipeline. A group of Portuguese youths have brought a case to the European Court of Human Rights, where they are also challenging, in this case, the policies of 33 countries based on fundamental provisions of human rights. That case has actually been admitted, but it is still in train. Now, just as a final wrap up and to set the scene, I want to talk about the fact that we do still have these climate change litigation hurdles. We've already discussed standing as a significant hurdle, whereby claimants have to demonstrate that they have suffered an injury in fact, that it's concrete and particularized, and that it's actual and imminent. This is the US standard, I should say. The injury needs to be fairly traceable to greenhouse gas emissions, and the injury needs to be redressable by the judicial branch. So that's a very high hurdle for cases, at least in the United States. We also have causation issues, as you can imagine. Now, I think the causation issues will be helped very much by the latest IPCC report, as well as other advances in climate science, but it does still remain very difficult to pinpoint the effects of particular emissions and connect them to specific events or culprits, shall we say. Justiciability, we have already talked about, is also a very difficult challenge. Many courts will find that climate change is a political or global policy issue and therefore inappropriate to be addressed by the judicial branch. And finally, we have issues of apportionment, meaning although there may be sufficient evidence to demonstrate that climate change is happening, it may be difficult to prove it in a particular case, and then also how to attribute or apportion liability to a particular state, company, or individual. Those are some of the challenges, and I know that David will talk about others. Finally, the future of climate change litigation, we clearly will have more regulation that will provide a foundation for litigation. For example, the EU's Green Deal and perhaps other statutes that will provide hooks for claimants. We know that we're talking about this promise of a green recovery. And as part of that, companies and governments might be held to account to the promises and commitments they make by way of court action. We will envision more climate litigation to hold governments to the 1.5 degrees Celsius climate objective, particularly if they fail to make effective and measurable commitments at COP26 coming up in Glasgow. And finally, we're going to see a lot more litigation spurred in part by the Shell decision that's been discussed, attempting to hold companies to account for past, present, and future emissions. I think companies will be expected to play an ever greater role in sharing the burden alongside governments and in transforming their behavior. And this litigation will focus not only on sort of remediation of climate effects, but also on things like adequate disclosure of climate risks, the scope of directors' fiduciary duties, and also on mis-selling claims such as greenwashing types claims. So we do expect a flood of oncoming litigation in this area. So in conclusion, I want to thank you for listening, and I love to have a conversation with the rest of the group.
Thank you very much, Suzanne.
Let me stop sharing if I can.
Thank you. Thank you. Before I hand over to David for his presentation, I just wanted to acknowledge, welcome and thank the presence of both Queen Noor of Jordan and President Salinas. So apologies for not knowing at the beginning about that. So welcome and thank you very much to both of you for your attendance today. We are truly honoured. David, I'll hand over to you now.
Thank you. Can you hear me all right?
Good.
Are you able to hear me?
Yes, we can hear you, David.
Okay, thanks very much. Yeah, well, I think Suzanne did a great job of outlining some of the recent litigation and some of the issues that are raised in this type of litigation, I mean, basically we have to ask ourselves why are citizens, and primarily in many countries in the world, actually bringing litigation in their courtrooms, in their domestic courts, about what is in effect an international problem? And the answer basically is because, first of all, they're frustrated by the fact that governments have made pledges, recognize that climate change is dangerous since 1994 when the UNFCCC was entered into force. They agreed again and they reiterated their acknowledgement of the dangerous nature of climate change at the Paris Agreement. They know what has to be done, and yet it's not being done. There's much more greenhouse gas rhetoric happening from politicians at these meetings than actual practical action within their own countries to ratchet down the emissions. So, citizens are, and particularly led by youth in many countries, are saying, don't we have rights? Why isn't our government acting? And they say, can we go to the International Court of Justice? No, the answer is no. There is no international forum where people can go to deal with this. That court is only set up to deal with claims between countries. And even then it requires consent of the defendant countries to be a party. So people have started to go to their domestic courts. That was illustrated by the TheUrgenda decision in 2015. And what judges in domestic courts are somewhat scratching their heads when they're faced with these actions, but they're actually getting quite interested because, I mean, after all, judges are humans. So maybe they don't act like it all the time, but they have children, they have grandchildren, and I think they're starting to get the fact that there's a very dangerous condition out there. It's well recognized, and that no other branch of government seems to be doing anything about it. People do have rights, different kinds of rights in different countries, but they're asking these domestic judges to protect them from this harm. And so some of them are doing that quite effectively. But there are problems in getting into court in these types of proceedings. And that's because we have procedural issues developed over the last several hundred years in our legal systems that were mainly intended for different types of disputes, say between company A and company B, or between party A and party B, and didn't have to deal with these worldwide diffuse sources of climate change and climate harms. So when we at the IBA wrote our first report in 2014 about climate change, justice, and human rights, we recognized that there needed to be specific attention paid to what could be done through the court system. I mean, we recognize that litigation is not going to be the panacea to solve the problem, but it's certainly, as is the TheUrgenda case and several others have shown, it's a very powerful tool when it can be brought in a forum where everything is laid out for the judge. They can understand it, and they understand that they actually have some opportunity to do something. So what we did in this model statute was to try and identify what are those procedural challenges that need to be dealt with and how they could be dealt with in a way that made sense in different countries. And so we had an expert committee comprised of leading lawyers, practitioners, judges, academics, and we looked at what kind of examples there were in around the world that might address some of these problems. And we put together this model statute. This model statute is not meant to be a complete thing that has to be adopted by any particular jurisdiction. What it is, it's a menu of it identifies the procedural issues. It identifies particular solutions that are based on, where possible, precedent in other similar ways, and then says and leaves it then to practitioners and politicians and people within any particular country or state to say, we need to change our laws, we need to change our approaches, and to allow more effective citizen litigation to prod governments who are failing to act on climate change. So this is what this document is. Let me take you to it. So let me see if I can get the PowerPoint going here. So the model statute has about 23 different articles. articles are specific words that talk about specific problems and give a solution that can be adopted by particular jurisdictions. But before you get into the articles, there's background, as this PowerPoint indicates. There's 25 pages of background and commentary on the existing challenges against actions for government, against challenges to government to get on with things. We document the ongoing efforts to promote government climate change action, and we then talk about lowering hurdles and recent developments. There's 227 footnotes or endnotes in this thing, so there's lots of resource materials for people who really want to get into the details of it. I'm just going to scan through the title of the articles just so you get an idea. I'm going to then focus on a few key ones. So we're obviously going to deal with standing. We're going to deal with the use of the IPCC reports, the ones that Suzanne mentioned, because these are authoritative, and we shouldn't have to relitigate in a courtroom what this eminent group of scientists from all over the world have identified as being the problem and part of the solution. Then we get into different things like assessing risks, burden of proof, use of environmental impact assessment, access to information, getting documents before you go to court, etc. And then we get to things that are really perhaps quite germane on this topic. For example, Article 16, restrictions on defenses available in government-related climate change proceedings. I want to try and talk about that for a couple minutes. And then we want to talk about costs of going to court, because in some legal systems, even if you get lawyers who are acting pro bono for the applicants or the plaintiffs, if the people who bring these cases lose, they could be potentially facing liability to pay the costs of the government, even though the government really doesn't need money from the citizens, but they often try and intimidate citizens by asking for those costs. So we've identified how this can and has been dealt with in other cases and in other jurisdictions. So let me highlight the key things I want to mention. Article 4 and 5, talking about standing. Suzanne mentioned these issues. And then the costs issue, then the restricting government defenses, judicial notice of IPCC, and I want to talk for a minute about the precautionary principle and shifting burdens of proof in these types of claims. So standing, how can you deal with standing? Well, we had the benefit on our our working group on this issue of the model statute of having the Honorable Justice Brian Preston from the New South Wales Land and Environment Court. He's a chief judge. He's been there for a while. He's very experienced, and he said, why shouldn't there be what's called open standing? We've had it in New South Wales for years, and over the years, there's probably 5 cases where it hasn't resulted in the courts being flooded with applications. To illustrate what I mean by open standing, he said, David, if you fly into Sydney and you want to come into my court to argue something, you're welcome. You don't have to, come up with fancy legal reasons or expert or a long list of evidence about what you have done before. You would be, we can give you standing. And so this is a concept that could be useful, and so it's identified in 4.1. Any person may bring proceedings to enforce rights, duties, or obligations and that pertain to the environment. And let me just get up my copy because I can't read it entirely on the screen. To restrain a breach or threaten or apprehended breach of or remedy a breach of legal instruments in government-related climate change proceeding, whether or not any right of that person has been or may be infringed by a consequence of that breach. This kind of language is important because cases in Europe in particular have been thrown out in the last few years by people trying to challenge it. The Swiss women who were senior women who were particularly affected by the heat and said the government of Switzerland has a duty to act more diligently to protect us. They have to get on with doing something about climate change. And the Swiss government basically said, well, you're no more affected than anybody else. really, even though the Swiss senior women filed expert evidence that they were, and said, we can't hear you, you have no standing. So this type of provision would deal with that, just as it would for the citizens in Europe, the People's Climate case, who wanted to take the EU to court for not having a sufficiently stringent plan to deal with climate change. That case was thrown out at the first level for the same type of reasons, because of things like that are in many of the European domestic law rules for dealing with litigation. Then there's another form of standing, public interest litigation standing. And this is, so this one's a bit different, but it's also helpful. We use it in Canada. I can assure you the courts are not being flooded with this type of litigation, but it's very useful when you want to bring a case. Basically, any person may bring government-related climate change proceedings if that person can establish, first of all, a serious issue is raised in the proceedings, B, a genuine interest in the issue, and in the case of an organization, an objective or mandate to protect the public interest. And what is public interest litigation? Well, it's defined as any government-related climate change proceeding that is pursued against a government or public agency by or on behalf of individuals and involves climate change, environmental or community organizations, or any other entity which has the objective to protect the public interest through mitigation, adaptation to, or otherwise responding to the likely adverse effects of climate change. So we've defined what that should be, and this is a concept that is used in Canada now. It was developed in effect by the Supreme Court of Canada, and it's usefully used. Now, we also thought that it would be appropriate to encourage countries and jurisdictions to clearly allow for interveners and amicus curiae, friends of the court, standing. So interveners, some organizations might want to say, well, some private people have started a case, but this is a broader matter. The court would be benefit if we were to be allowed to intervene and give you some input, because you may not get everything you need from the particular parties. And you know, this happens a lot in many jurisdictions, but we define some appropriate rules on what could be done to grant standing for that, as well as amicus curiae who could participate to provide expertise and guidance and help to the court. Then here's Article 6 is very important, I think, to recognize. Here, what we try to do is prevent the courtroom from being diverted by somebody trying to argue, well, you can't rely on these findings by the IPCC, the Intergovernmental Panel on Climate Change. You know, if we're a defendant, we should be entitled to question all of that. We should be entitled to call our own experts. And all of us on this working group, Roger and Justice Preston, when he was co-chair, he was needed to leave the task force at a certain point, and Roger took over as co-chair. But we all agreed that you know, there's no point in allowing these cases to turn into a rehash or be diverted into a trial within a trial of whether or not climate change is happening, whether or not it's occasioned by human activity, and how bad it is. Rather, we said, we have this eminent group of scientists. The IPCC are representatives of every country in the world. They're scientists. They don't write their own, they don't make up their own studies. They review other people's studies. And no report of the IPCC can actually come out unless all scientists have agreed on almost every sentence. So it's the best peer review process in the world. So we said, why would you not allow that to be put in as in what many countries judicial systems recognize as judicial notice? Courts are entitled to take, quote, judicial notice of things that are widely known, widely accepted, and it seems to us that that is what is the status, or should be the status, of IPCC reports. And so basically we say the court shall take judicial notice of the findings and conclusions. The court shall accept the findings and conclusions as prima facie proof of the findings, And if a party wished to challenge any statement, they'd have to get permission of the court, but there'd be conditions like, for example, it won't be granted unless they can demonstrate a reasonable prospect of success, that it won't unduly delay the disposition of the substantive claim, like put it off for a year or two while they're fighting about this. And they have to bear the proof, burden of proof, and they might be required to pay the costs or allow the other party to have some experts to help them out. The other things are things like assessing risk and standard of proof. Judges should be, in effect, undertaking a risk assessment if some case comes before the court, and before they make a decision about whether or not they even what they should do about it, or even perhaps if they're going to throw it out on an argument about standing, they should at least be thinking about what are the consequences. What are the potential risk of the likelihood of the threat that's being talked about being realized? What are the severity of the consequences, and how long is it going to take? And in particular, the court should take into account things like potential effects with low probability, but a significant potential impact. And we even said that in making these evaluations, the court should not require proof that the matter is more probable than not, which is a common standard in the common law system. And we talk about the court should use a precautionary principle, which means, as we say here in the second paragraph, that where there are threats of serious or irreversible damage, lack of full scientific certainty should not be used as a reason for postponing cost-effective measures to prevent, mitigate, or adapt to climate change. And if a party wants to challenge the use of the precautionary principle, then we said they bear the burden of trying to convince the court why that should be applicable. There's EIA. This talks about environmental impact assessment. We said that courts should have people should be able to go to a court and say, in order to prevent future damage, governments should be assessing the potential impacts of projects and activities before they're authorized, before they're licensed, for their climate change impact. And we said sometimes and often that isn't done, or it isn't fully done. So people should be able to go to their courts and ask a court to examine the adequacy of the EIA. And if the government, and if the court is not convinced that one's been done at all, or it's not been sufficiently done, then the court should have the ability to critique it and articulate the things that need to be done before that project is further approved. We talk about access to environmental information as part of a litigation process. These are important things, but I'll skip through them at the moment. Pre-litigation disclosure should be made available, again, to assist this litigation being done in a sensible, efficient manner. Then we get into things like costs and the concern that we need to take measures to reduce the chill of potential public interest legal fees and court cost liability. And we provide examples from other countries where this is done through orders that the judge can make in advance to set a maximum on costs, and there's other techniques such as, let's see if I can do this. The next one. Advance cost orders. They could order the government to actually give money, to order a party to pay advance costs. And then there's cost shifting. And this is perhaps the most useful thing. In government-related climate change proceedings, except in exceptional circumstances, the court is, we think, appropriately to order an unsuccessful government defendant to pay the costs of the successful plaintiff or applicant, or not to order the unsuccessful plaintiff to pay costs that government may claim, even though the government has successfully defended the case, or to consider whether the unsuccessful plaintiff should be, in effect, awarded costs against the government for upholding or advancing a public interest issue relating to climate change. So these are concepts we didn't pull out of our head, but rather things that actually exist in some jurisdictions already and many courts have agreed with. So these are things that could be done. Let's see if I get to the next one here. Okay, so let's get to some of these. Whoops, I think we went too far. I can go back. Restrictions on government defenses. Now, this is really something that's just want to spend the last couple minutes on. So as you've heard, there's been, well, when cases are brought against government, there are three major defenses that have been offered. First of all, they argue, well, they would argue, well, we're not the only country in the world that's doing this. There's 150 other countries, and Holland argued that the first time around in TheUrgenda. And they also said, and even if you look just at Dutch emissions, they're 0.05% of the world's total carbon emissions. So again, what's the point, Judge, of ordering us to do something when everybody else would have to also do something at the same time? Otherwise, in effect, your order to us to reduce emissions would not be effective. And thirdly, in the TheUrgenda case, they also argued that setting emission targets and ordering us to, as a government, to reduce our targets is really a political decision. That's for the government. It's not something that courts should get their hands on. And you know what? At all levels of court in Holland, the first court, the Court of Appeal, and then the Supreme Court of Holland, they all rejected those defenses. And let's just see what they had to say about it. If I can get this in here. So here's the quote from the Dutch Supreme Court in a year ago or so. They basically said what we're saying here. States made this assertion that that it's not for the courts to undertake the political considerations necessary for a decision on the reduction of greenhouse gas emissions. However, now this is direct quotes from the decision. In the Dutch system of government, the decision-making on greenhouse gas emissions belongs to the government and parliament. They have a large degree of discretion to make the political considerations that are necessary. That would be true, I think, most countries would, and most judges in other countries would say that. However, here's what the court actually said. It's up to the courts to decide whether, in taking their decisions, the government and parliament have remained within the limits of the law by which they are bound. This mandate to the courts to offer legal protection, even against the government, is an essential component of a democratic state under the rule of law. And the court emphasized that. And they also said this, that because the rights are given under the European Convention of Human Rights, Articles 2 and 8, the right to life and the right to protect, the right to be, for family life to be protected from government and private sector impositions on these rights. They said the state has an obligation to take suitable measures to prevent those impacts from occurring. These include preventative measures against the danger, even if it's not certain the danger will materialize. And the main thing here is what I've put in bold type. The judge may examine whether the measures taken by the state are reasonable and appropriate. The policy of a state in taking action must be consistent, and the state must take action in a timely manner. The state must observe due diligence in its policy. The court can verify whether the policy pursued meets these requirements. So the courts in Holland are definitely clear. There is a bright line, and we have a role. And why isn't that appropriate? It is appropriate because if you've got the problem of governments not acting in the first place, then and rights are being impacted, then surely the courts should have the opportunity to protect people from these problems. And then in Canada, there was a case brought by youth in the province of Quebec, challenging Canada's lack of rigor in terms of trying to reduce its emissions. And they invoked the Charter of Rights, the right to life and security of the person in our Charter of Rights, which said, government, we have rights, and the government's inaction is impacting our rights. The Attorney General of Canada argued that's not a justiciable issue because, again, like the Dutch government, setting policy is up to the government. Well, here's what the judge said in rejecting that. He said, these claims that Canada's choices appear to be at this stage aiming at the exercise of the executive power, while the order sought to stop any violation, according to the government, seems to be linked to the legislative process. And he went on to observe, courts generally do not interfere in the exercise of the executive power. But the words in bold, but in the case of an alleged violation of the rights guaranteed by the Canadian Charter, a court should not decline jurisdiction on the basis of the doctrine of justiciability. So that's sort of where it's at. And there are, I mean, on this issue, there are cases, strong statements whereby people should not be thrown out of court.
David, may I just interrupt you? We have about 1 minute to
I am finished.
on to our next session. If I can ask you to draw it to a conclusion.
Yeah, I am. Thank you. It's great timing because that's all I wanted to put up on the screen. I wanted to thank everyone for the opportunity. I'd be glad to try and deal with questions if there is time available. But I think there's something there in every country, and it's really up to people in each country to know that this is there and try and get these things implemented in various ways. And we can talk about that if you want at some point. Thanks very much for your attention. I'm happy to have participated.